now like to ask Sarah Lee to join us to introduce Martyn Day. Sarah was the co-founder of Lee Day and Company, the legal company. She's now retired from the law, although very busy doing lots of other things. Anyway, she's known Martyn for a long time.
I certainly have. Yes, well, I first met Martyn in 1981, which is quite some time ago now, and I get 2 minutes to tell you all about him, which is a bit of a tough assignment. I met Martyn at a job interview, which I remember very vividly. I don't know if he does. I don't remember any of the other people who applied for the job. I was then a partner at Byman and Partners doing immigration and asylum law. Martyn had decided he wasn't ever going to do any personal injury law anymore. He was going to do human rights work. And he was applying for this job. And we gave him the job really because it really seemed as if he would be quite fun to work with. I mean, he sort of bounced in very cheerful and ebullient, very sunny. And I have to say, he's been sunny and ebullient ever since. He didn't look terribly sunny and ebullient on that thing, but anyway, you are. And he has been fun to work with. So it's all gone, I think, reasonably well. In 1986, we started Lee Day, which was going to be a small niche personal injury firm. We weren't going to have lots of staff. We were just going to run our own cases and live a quiet life, do a good job for our clients. And somehow the whole thing got away from us. I really don't know how it happened. Every few months, or every 18 months or so, we'd have to get a bigger office. And I used to say that being in the firm is a bit like being tied in a sack and thrown down successive flights of stairs. And every now and then you used to open the neck of the sack and look round and see where you were and how many people were with you. And so, but that makes it sound painful, and it wasn't really. Not at all. I have to say, I mean, I can't resist one story about the early years, which is about Martyn's total inability to get to grips with IT. Initially, because I got him a computer. I was quite keen on all this. This is long, long ago, of course. And I got him a computer and put it on his desk, and I suppose he got some training in it. And after about 6 months, he said to me, "That telly on my desk, never anything on it. Take it away." So I did. However, I was about to say under the mask. I don't really mean under the mask, but under this sunny, cheerful exterior, there is a very determined person who's been shaped by big issue after big issue over these last 20 years. The first was Sellafield, which involved young children dying of leukemia. And that was very hard for all of us. And since then, I've watched a series of big issue cases make their mark on Martyn and other people in the firm. And I wonder if everybody in this room realizes what a huge drain on one's energy these huge cases are. I mean, I've run major medical negligence cases for 20 years, and I thought that was bad enough. But watching Martyn and some of my other colleagues run these cases, I realized what a tremendous amount of energy, resilience, commitment, and just sheer courage they require. And that goes for Paul as well as for Martyn. They are the most terrific trial. So before anybody in this room thinks they'll plunge into all this, I suggest they think twice. Anyway, Martyn's going to tell you about the last one.
Thank you very much, Sarah. And part of the ethos of my speech was to try and encourage people to join this field. So thank you very much for that, Sarah. Very nice to see so many people here, so many friendly faces, a few not so quite friendly faces, but generally lovely to see everybody here, and total brilliant job that you've been doing, Chris, in terms of the centre. I think it's an absolute accolade to you and the team. It's fantastic to see quite so many people here and so interested in this field. Much due to you. Well done. What I wanted to do today is Paul talked a bit about it in detail about some of his cases. What I was going to do is talk a little bit about some of the cases that we do as a backdrop, but to try and draw a few strands together in terms of understanding where we got to in this complex field that we have. Paul and I met for the first time today for lunch, and we were agreeing how few lawyers, in fact, there are in this particular field, whether you're talking about the UK, the US, or indeed the world. And I think probably between the UK and the US, we're probably 70 or 80% of the market, and even that is pretty small. So it's a very small field, and it's a shame that it is so. And I think that's one of the important points of all this, as to why it is quite so narrow. One of the things that strikes me, the question was asked to me a bit earlier, what drives me, what gets me out of bed in the morning? And it's a difficult thing to decide, whether is it to become a member of the Hoffman pest team? Is it because I kind of felt very early on when I started off in a commercial practice in the West End that this just wasn't for me, and I realised that in the end my heart wanted to stay with me when I went to work and not left at home. But whatever it is, I kind of feel this driven passion to make sure that wherever injustice is done in the world, that we are there as a firm to try and give people the support that we can. And I assume from what Paul has said, he feels very similarly that the few firms that there are in the world who are prepared to put our resources at the disposal of people who have suffered loss, damage, injury as a result of the actions of multinationals, then that's where we want to be, and that's where we want to put our time and effort into. Now, the battles against multinationals are undoubtedly tough. I've got a lot of respect for them in lots of ways. I've got no feeling that they're the devil incarnate. Not to say that they're not, some of them are a bit of that, but mostly they're quite decent people. But in the end, you have a system which encourages multinationals and their lawyers to operate in a certain way. They will not pay up compensation. They will not accept liability. They will not admit that they've done wrong unless they're absolutely forced into it. It's a natural reaction. It's a natural part of the company process is to maximise profit and to maximise their identity within the community. And admitting fault, admitting that they've caused damage to communities is not a major part of that play. Now, the crucial thing is therefore not to demonise them, but it is to recognise the imbalance that is in virtually every system when you get communities that have been damaged, injured, lost out as a result of the actions of multinationals. How do you ensure as a society that that imbalance is met? Now, we've acted in a number of cases, which I'll just quickly run through, because I think to understand where we're coming from, you need to understand a little of the work that we do. It's rather similar to what Paul's doing, so I shan't spend too much time on it. But, for example, we acted for 7,000 asbestos workers in South Africa, a few hundred in Swaziland. We're able to get them compensation by suing the headquarters here, Cape PLC in relation to the South African ones, and CNN in relation to the Swazi ones. We acted in Colombia and still acting in Colombia in relation to a pipeline that was built partly by a grouping which included BP. We're suing BP here in relation to the operation of the pipeline and the damage that is alleged was caused to the peasant farmers of Colombia. We are acted for a number of Maasai, just over 1,000 Maasai in Kenya, who said that they've been damaged by bombs that had been left by British Army when it was operating in Kenya in terms of its practice. They left unexploded ordnance around. The young Maasai kids picked up the bombs, they exploded and took off arms and legs and obviously killed quite a few of them as well. And we were able to successfully gain compensation for a lot of Maasai. We're acting at the moment for the Mau Mau in a historic case, looking back at what happened in the 1950s in terms of the emergency period in Kenya in relation to the torture and ill treatment received by them at the hands of the British colonial regime at the time, and that's ongoing as well. Ongoing at the moment, we have cases against Anglo-American in South Africa. We're suing in relation to the operation of the gold mines, the fact that many thousands of people suffer from silicosis in that part of the world. We are acting in relation to a number of Iraqis, particularly the Baha Musa case that many of you will have seen and heard about in terms of the poor guy who was murdered by British Army troops back in 2003. A lot of other Iraqi torture cases as well. And we acted, obviously, as you've just seen, in relation to the Trafigura claim.